calling for an expedited hearing. Eventually, the Supreme Court set a date for today, only for the parties to pray for leave to amend certain processes and all of that. Let's speak to him and see what he thinks about this. Of course, he's a private legal practitioner himself, MP for South Dai, the Honorable Roxy Nelson Dafeamekpor. Hello, good evening, sir. Welcome to Eyewitness News. I'm sure you followed proceedings in court today. Were you in court yourself?
No, I'm in Ho with the Public Account Committee. So
okay, very well. But I guess whilst you were at the committee level, your mind was really in court.
I monitor proceedings.
Very well. So what does today's proceedings mean for you as a proponent and the bill itself?
Thank you very much. One, I got worried by the adjournment sine on grounds that by practice, matters such as this, that one has high public interest, and two, being heard pursuant to a specific request by a party for expeditious hearing, the court normally or ordinarily would adjourn the matter to a definitive date and then give timelines for parties who have been directed by the court to file processes to do so. So, for instance, if this matter were adjourned to, say, 30th of May, the court would have directed that, well, the plaintiff, if as directed or minded, could file processes within 4 days after today. Then when such processes are served on the defendant, then the defendants, if they are minded or as directed by the court, will also file within 4 days after the service of the processes. So within a matter of 8 days, the upper ceiling 8 days, any process that ought to have been filed in the matter or any party that ought to have put his house in order to file the process would have done so. So when the court returns on, hypothetically, on 30th of May, there will be nothing outstanding, save to deal with the motion before it and determine the matter. But not having done that, the matter is now in abeyance. In abeyance in the sense that it's been adjourned for the parties to put their house in order and file the process, is not giving any timelines within it to do so. That is what bothers me as a lawyer, first of all, and also as an officer of the court, and above all, as a sponsor of the bill that the life of which has been placed in abeyance as a result of this pending application or notice for a grant of an injunction. If you juxtapose the conduct of the Attorney General for me in this matter vis-a-vis his conduct in my case, when he applied for expeditious hearing or he requested for expeditious hearing in my case, he saw the alacrity and the speed with which that was determined. Then he went to sleep. And so Speaker also decided through his lawyers to ask for expeditious hearing. And this was done sometime on 27th or 28th of March. And it's taken nearly 6 weeks for that to be done today. And even though it's taken 6 weeks, now we don't even know when we are going to come back. And it's a big bother for me because Parliament, at the end of this month, hopefully, will be returning from recess to deal with some outstanding matters, including perhaps the bill that is in question. It's part of the business that is still outstanding before Parliament. So it's in everybody's interest that we get some of these matters out of the way so that we can see our way clear going forward.
Are you concerned that given that the matter is being adjourned sine die, we may not see this matter determined in this legal term or legal year? Of course, the courts go on vacation by end of July, return in October. And I'm not sure when Parliament will be around and all of that, and elections will also be approaching. Is it your concern that the matter may not be determined in this legal year before the courts go on vacation?
You and I are practitioners, so it's one of the possibilities. The other possibility too is that if the parties put their house in order and file the processes quickly, then another request could be served on the registrar of the court to issue hearing notice for us to come back in a quite recent future. But there are all possibilities. And this is why the court ordinarily doesn't do this. The court will pin you down to time within which, as a party, you have to act, so that the court can proceed with the matter, because there's an application for expeditious hearing. These are the tenets of expeditious hearing. Expeditious hearing doesn't follow normal hearing, doesn't follow the course of normal hearing. No, things are done with alacrity, with speed, with dispatch, and without wasting time.
I see. Many have also asked, so that's fine for the court and all of that. Many have also asked that what becomes the status of the bill if, let's say, the court is not able to determine the matter before Parliament is dissolved, the new Parliament comes. Ordinarily, we know the bill will have to start its journey again. But given that Parliament has passed it, what is outstanding is the assent of the President. Does the absence of the assent of the President, return it to 0, where a new Parliament will have to start all over again? Or because Parliament is past it, what will be left will be for the new president, whether John Mahama or Bawumia, to just assent to it? I don't know if you get my question.
Yes, I do. You see, it depends on the interpretation that is placed on what constitutes a bill. A bill, for me, becomes is cooked when it is passed by Parliament. There is an interim procedure between when it is passed by Parliament after the third reading and the procedure outlined under Article 106 in the Constitution. That is an administrative procedure of conveying the bill to the office of the President. It's also a constitutional imperative. Now, but when you define the bill as still remaining a bill until it receives the presidential assent, then technically speaking, when the life of this Parliament ends, then the life of our bill is killed. It has to be introduced in the next Parliament. But for me, Parliament has done its work. In terms of the legislative duties, it has done its work. That is why the duty of presenting the bill is no longer left in the hands of Speaker or Speaker, but it is left in the hands of the clerk to Parliament. It's an administrative rule. It's an administrative function. It's a clerical function of conveying the bill by a covering letter to the office of the President. So if it stays at the office of the President and the life of this Parliament ends, then any president who takes over will have to deal with it within the meaning of Article 106 of the Constitution.
Very well. Thanks so much. The Honorable Roxanne Nelson, Dafeamekpor, MP for South Dai and a private legal practitioner, sponsor of the Anti-LGBT Bill, which is currently a matter for Supreme Court determination. Eyewitness News on 97.3 Citi FM. We'll take a short break, return and tell you more. Of course, your text messages have been coming and we'll read some of them out to you. Don't go away.
Eyewitness News. Be there as it happens.